Locke on Legitimate Government and Rebellion, Lecture 1. So, in the previous lectures, we talked about Locke's understanding of natural rights, and then we also got to Locke's claim that because people are by nature free, that means governmental authority must be derived from the consent of the governed, and his argument that the purpose of government is to secure people in their natural liberties, or to secure them in their life, liberty, and property. In this reading, we look at a few things that Locke has to say about the proper kind of powers and limits and structure of government. And in particular, we'll look at Locke's account of the separation of powers, his account of the limits that have to apply to the legislative power, and his argument for the justifying rebellion against the government under certain cases, the right to revolution, which is, of course, the last big right that is invoked in the Declaration of Independence. So to begin with, in Chapter 11 is called The Extent of the Legislative Power. And there, he's talking about what the legislative power can do and what its limits are. And so let's say, okay, fine. Okay, Locke, we agree with you. We need government. We need consent in order to establish it. But how do we actually set up a government that will do those things? Not just any old government will do. How do you establish a government that actually does the job of protecting people and their property, which Locke says is the purpose of government? Now, one thing he makes very clear in Chapter 13, sections 149 and 150, is that once a government has been formed, the legislative branch is the supreme branch. The legislative power is the supreme power of the government. Now, obviously, ultimately for Locke, the ultimate source of sovereignty is the people themselves. The people, or the majority of the people, determine what the government will be. So the ultimate source of authority in any society is the people themselves, because they're the ones that authorize a government, that adopt a constitution. But once a government has been established, the preeminent part of that government is the legislative power, the legislature, the ones who make the laws, because it's prior in the way that government works, right? The executive branch enforces the laws made by the legislature. The judicial branch, or judicial powers, interpret and adjudicate laws made by the legislature. So the legislature is the power that gives the other powers their job to do. But now, does this mean then that once the legislature has been created, that it can make whatever laws it wants? No, right? Because who created the legislature? The people. Why did the people create the legislature? To protect the people and their life, liberty, and property. And so this is why, as we'll see later on, he argues that if the people judge that the legislature is not doing the job that it was created to do, that it is actually thwarting people, that it's actively and deliberately harming people, under those circumstances, the people have the right to alter or to abolish the government. Right? So say, look, we created the government to protect us. If it's not protecting us, then we don't owe it our allegiance. This is section 149 and section 222, right? And that's what the Declaration of Independence says. And this is one way of sort of showing how kind of Locke's understanding of the natural law does sort of sit at the basis of political authority and set its limits. No government can legitimately do anything contrary to the law of nature. The government's primary obligation is the preservation of the community. As he says in section 134 about the first and fundamental law of government is to preserve the community and everyone in it to the greatest extent possible. As he says, the great end of men's entering into society being the enjoyment of their properties in peace and safety, and the great instrument and means of that being the laws established in that society. The first and fundamental positive law of all commonwealths is the establishing of the legislative power. As the first and fundamental natural law, which is to govern even the legislature itself, is the preservation of the society, and as far as will consist with the public good, of every person in it. End of quotation. So the job of the legislature is to preserve the society. This is just an application of the law of nature to the community as a whole. Each person joins for the sake of self-preservation, for the sake of the preservation of their natural rights or their individual rights. And so the goal of the legislative power or the legislature is to make those laws that are necessary for preserving the community and its members. So in that sense, you can say the natural law sets a kind of limit to the legislative power. And the natural law never goes out of force, right? The natural law, as Locke conceives of it, is basically derived from God. And so no human authority has the right to act against it. They oftentimes will, they'll try to, but they're wrong to do so. And so then, and this is summarized in section 142, although he talks about this in sections 135 through 142, he talks about 4 particular limits that, in effect, the natural law sets to the powers of the legislature. He says in the first case, the legislature cannot rule arbitrarily. Right? What the legislature is there to do is to make rules that we all live by. So the legislature cannot just arbitrarily order people around, acting like an arbitrary monarch. The way the legislature acts is by making common rules that apply equally to all. So that's why he says in sections 135 through 137, the legislature has to rule through promulgated standing laws. Promulgated means you've got to make the laws publicly known. People can't be held responsible for abiding by laws that they don't know exist. So the legislature has to make laws, it has to publish those laws, and they need to be standing laws. And by standing laws, he means they have to be pretty stable. Because if you're changing the laws all the time, there really isn't law. You really don't have law if you're constantly changing the rules. So the legislature has to act through promulgated standing laws. The second limit is that those laws must be limited to what's necessary for what he calls the public good. Right? For these laws to be legitimate, they have to be, there for the preservation of the lives and liberty and properties of citizens. So the government doesn't, in the same way that the legislature can't act arbitrarily, it's also the case that the legislature has no right to make laws that deliberately harm some or all of the community in their lives, liberties, or property. So, promulgated standing laws for the public good. And that's the most basic sense of what he means by the public good, that these are laws that help the society to preserve itself, to be prosperous, and the legislature doesn't have the right to make laws that actually inflict harm deliberately on the community. And then there are 2 other limits. The third limit to the legislature is that you've got to get the approval of the people or the approval of their representatives in order to raise taxes. No taxation without representation. Since the purpose of government is to protect the property of citizens, right? Because without the right to own things, you can't preserve yourself. It's the case the legislature cannot tax the people, take their property, without the consent of the people or their representatives. Because if the government had the right to take people's property whenever it wished, then there's really no point to form government in the first place, because the government will be even more dangerous, because more powerful, than any aggressor in the state of nature. Right? So your property is not going to be secure if you create institutions that can arbitrarily seize your property. So now Locke is emphasizing this because in his time, the laws in England and Britain were made by the Parliament, and the Parliament was made up of the House of Commons, which was elected, but then also the House of Lords. And the House of Lords were hereditary aristocrats. They weren't elected. They held office because they were born into aristocratic families. And so the tradition developed in England that whenever the people are to be taxed, those taxes must be passed by the House of Commons. Those taxes must be passed by people who are themselves accountable to the community. So for us, the no taxation without representation is sort of it's not a specific requirement, because all laws, not just tax laws, but all laws are made by elected representatives of the people. But if you had some kind of situation where you had lawmakers who were not elected representatives, Locke would still say that when it comes to taxation, you've got to get the people's permission in order to do it. Otherwise, the government has way too much arbitrary control over the property of citizens. So promulgated standing laws for the public good no taxation without the consent of the governed. And then the last one, he says, is the legislature cannot delegate its power to make laws to some other body. That's section 141. The people invest the legislature with the authority to make laws. The people who make up the legislature do not inherently have the right to make laws. Right, like the 435 people who make up the United States Congress right now, they were not born with the right to make laws. They have the right to make laws because, as through election, that right has been given to them as a body. So, what that means then is that the legislature doesn't have the right to give lawmaking authority to somebody else. That's not a power for them to give. In the same way, like if I lend you my car, you don't have the right to turn around and give it to somebody else. Because I'd say, hey, I didn't give you my car. I just lent it to you for you to use. That didn't mean that you can turn around and give it to somebody else. I just lent it to you. So, in the same way, the authority to make laws is something that the community lends to the legislature. So the legislature can't turn around and say sell it to like Bob, right? Like why don't we just Bob's a billionaire, let's let Bob buy the right to make laws from us, and then we can sit back and relax and he can make all the laws. And Locke would say no, because a legitimate legislature has to have that power invested in it through the consent of the governed. So the legislature can't turn around and on its own give that power to somebody else. Only the people get to decide who makes the laws. So Congress, it does not have the right to give some other body the power to make laws for U.S. citizens. Only Congress can do that because the people specifically gave that power to Congress in the Constitution and not to anyone else. Now, that's a limit on legislative power that is routinely violated really for the last 100 years, at least in the United States. A lot of the rules that we live under are actually made by governmental agencies that have been given that authority by Congress. And so Locke would probably disagree with that. He would probably say that's illegitimate. It's a violation of the principle of the consent of the governed. But that's a different controversy, and we can get to that in a later lecture. But so for Locke, the four limits to the legislative power are the legislature can't rule arbitrarily. It has to rule through promulgated standing laws. Those laws must be for the public good, no taxation without the consent of the governed, and no delegation of the legislative authority to anyone other than those who have been given that authority by the people. Now, this then gets us to the executive power. Okay, so the legislature, though it makes the laws, Locke argues, should not also have the power to enforce the laws. There should be a separate governmental body, the executive, that is in charge of enforcing the laws. That's sections 143 and 144. And the main reason why is because Locke argues if the same group of people have the power both to make the laws and to enforce the laws, then you are going to get arbitrary government. Because what guarantee do you have if the same people who make the laws also enforce the laws? What guarantee do you have that they will actually make themselves abide by the laws? They're the enforcers. They might force other people to obey the law, but they're not going to force themselves to. They might not force their friends to, or their connections, other connections. So in other words, if lawmakers also enforce the law, then they're probably going to make all sorts of exceptions. They're going to exempt people from obeying the law. And at that point, you don't really have rule of law. You don't have one set of rules for everybody. Instead, what you have is a powerful body that decides these people have to follow the rules and these other people don't. And that's illegitimate. You can't secure yourself that way. So if the legislature both made and enforced the laws, you would have arbitrary government. And so this is the basis for the idea of the separation of powers, right? The idea of separation of powers is that the people who make the laws should not be the same people who enforce the laws. The legislative power and the executive power should be vested in separate institutions within the government. That to prevent abuses of power, the different powers of government should be placed in different hands, rather than concentrated in one body that might be tempted to abuse that power. So this is, Locke's basic argument for the separation of powers. In order to avoid arbitrary government, you need to have somebody other than the legislature be the one that's actually in charge of enforcing the law. And that's what he means by the executive. So the basic function of the executive, as opposed to the legislature, is to use the force of the community to enforce the laws, right? Primarily by punishing lawbreakers. You need to have government institutions to put this into effect, but that's the basic function of the executive. And so the hope is, since if you concentrate powers into one person's hands or into the hands of a small group of people, they're going to abuse that. So the hope is, if some people make the laws but don't enforce them, and other people enforce the laws but don't get to make them, then what you'll probably have is, or what you hopefully will have, is an impartial system where the rules are applied equally to everybody. So that's the function of the executive. Now, Locke, he goes on after that to talk about what's called the federative power. And the federative power, as I said before, and this is chapter 12, in chapter 12, sections 146 and 147, deals with the power to represent the community in its dealings with other political communities. So the federative power refers to the power to conduct foreign relations, to go to war, to make peace, to make alliances, and all of that. And as Locke says, even though the federative power and the executive power are different from one another. The executive power is inwardly focused. It's a domestic power. The executive power is about enforcing the law within the community, whereas the federative power is about securing the community in its relations with other communities. So the executive power and the federative power are different from one another, but as Locke notes, they tend to be exercised by the same person, right? So, for example, in the United States, the president, who is the chief executive, which is to say the one who is ultimately responsible for the domestic enforcement of federal law, the chief executive is also the commander-in-chief. The president is at the top of the chain of military command. The president is ultimately in charge of our diplomatic relations with other countries. So, with a couple of important exceptions, it is the case that the person who wields the executive power tends to also be the person who wields the federative power. And Locke says that the main reason why this happens is because both domestic law enforcement and foreign relations involve using force, using the force of the community, the police, and things like that, but also the military. And so it just makes sense for the force of the community to be ultimately under a single command structure with a single person at the top, right? That if you tried to have one person in charge of the execution of the law and another person in charge of the federative power, you could end up with conflict because they're both in charge of using the forces of the community. So what happens when they give contradictory orders? So to avoid that, you want to have ultimately one person at the top of the chain of command that's in charge both of domestic law enforcement and foreign relations. So that's Locke's account of the executive and the federative powers. In the next lecture, I'll talk a little bit about what he calls prerogative, and I'll talk about the right to revolution, and then we will be done with Locke.